impeach President Donald Trump, House Speaker Nancy Pelosi will finally send the impeachment articles to the Senate next week to kick off the trial over there in the Senate. Republican sources involved in the planning tell CNN that with this development, they think Trump could be acquitted by his February 4th State of the Union address, something Pelosi, according to sources.
In the shadow of a bitterly divided nation where the White House, Congress, and the Supreme Court stood locked in a high-stakes battle for the soul of American democracy, a federal judge named Darren Gales delivered a stunning rebuke that sent shockwaves through the corridors of power. On April 14, 2026, he didn't just rule against President Donald Trump. He formally declared that the president's incendiary calls for his impeachment were poisoning the very foundations of democracy itself, attaching a $10,000 fine and a chilling warning of escalating consequences if the attacks continued. It was a moment unlike any other in modern American history, a raw confrontation between the executive branch and the judiciary that felt cinematic in its intensity, as if the republic itself hung in the balance. The drama had been building for days, rooted in a lawsuit that many saw as both audacious and desperate. On April 13, Judge Gales had dismissed Trump's staggering $10 billion defamation suit against the Wall Street Journal in a meticulously reasoned 17-page opinion. The case centered on a 2003 birthday card linked to Jeffrey Epstein, a card that reportedly featured Trump's name scrawled beside a crude sketch, part of a broader swirl of documents tying the president to the disgraced financier. Trump's legal team had argued vehemently that the entire story was a forgery, a fabricated smear designed to destroy his reputation and presidency. They presented evidence, affidavits, and expert testimony, insisting the Journal had acted with actual malice, the high legal bar required for public figures to win defamation claims. But Judge Gales was unconvinced. In clear, unflinching language, he explained that Trump had failed to come anywhere close to proving that threshold. The ruling wasn't hasty or vague. It dissected the evidence step by step, citing precedents, outlining the standards of proof, and demonstrating precisely where the plaintiff's arguments fell short. It was the kind of judicial craftsmanship that legal scholars respect, transparent, appeal-proof, grounded in law rather than politics. Yet for Trump, it was a devastating blow, especially as the Epstein estate released additional corroborating files on the very same day, files that seemed to bolster the Journal's reporting rather than undermine it. The timing amplified the sting, turning what should have been a private legal setback into a public spectacle that dominated headlines and late-night conversations across the country. That night, the president's response erupted across Truth Social like a thunderclap. In a series of posts laced with fury, Trump labeled Judge Gales an Obama hack destroying America, decried the case as a rigged Epstein sham, and in all-caps fury, demanded the judge's impeachment. It wasn't subtle criticism or policy disagreement. This was a direct assault from the Oval Office, the sitting president of the United States, calling for the removal of a federal judge over a civil ruling in his personal lawsuit. The words hung heavy in the digital ether, amplified by millions of followers, supporters, and media outlets. They weren't just venting, they carried the immense weight of presidential authority, a platform that could sway public opinion, influence lawmakers in Congress, and pressure the broader machinery of government. By the morning of April 14th, Judge Gales had read those posts, and he had reached his limit. What followed was one of the most extraordinary court orders in recent memory, a document that legal experts would pore over for years, not just for its legal reasoning, but for its raw moral clarity. Gales didn't mince words. He wrote that Trump's threats of impeachment for judicial rulings represented a direct and deliberate attack on the independence of the federal judiciary. Such behavior, he stated, poisoned democracy by undermining the separation of powers that the Founding Fathers had so carefully constructed. It wasn't polite institutional language. It was pointed, urgent, and backed by action. He imposed a $10,000 fine and warned explicitly that further violations would invite even sterner measures. This wasn't a slap on the wrist. It was a line in the sand, drawn by a judge who saw the republic's guardrails eroding under relentless pressure. The emotional weight of that moment was profound. Here was the president, fresh from a historic election victory, and wielding executive power in his second term, clashing openly with the courts in ways that tested the Constitution's limits. For many Americans watching from afar, families in Portland grappling with protests, veterans reflecting on oaths to the republic, Everyday citizens worried about stability. This felt like a fracture in the system they had trusted. The judiciary, meant to be the impartial arbiter, was now under personal siege, and Gale's order captured that tension with cinematic precision, transforming a legal filing into a defense of democratic norms. To understand how the nation arrived at this precipice, one must rewind through the chaotic early months of Trump's second term. The Epstein files had loomed like a specter from the beginning, a tangled web of associations, documents, and unanswered questions that refused to fade. Trump's $10 billion suit was intended as a decisive strike, a way to quash the narrative once and for all. Instead, it had the opposite effect. By filing it, he elevated the story, drawing fresh scrutiny to the birthday card, the sketches, the 1,000+ mentions of his name in Epstein-related records. When the estate released more materials post-ruling, it only fueled the fire. Questions swirled. What exactly did the 2003 card say? How deep did the connections run? What had Melania Trump reportedly said in private about the files? These weren't abstract legal curiosities. They struck at the heart of public trust in leadership. Yet the contempt order wasn't isolated. It connected to a broader pattern of tension between the Trump administration and the federal courts, a pattern that had already produced constitutional fireworks. Earlier in 2026, Judge James Boasberg had held the administration in contempt over deportation flights. The White House had pressed ahead with removals despite a court order blocking them, sparking a fierce debate over executive authority versus judicial oversight. Agencies and officials were involved, creating an institutional standoff. Trump's team decried judicial overreach, arguing that courts were interfering with core presidential powers on immigration and national security. The confrontation consumed weeks of political capital, forcing defenses in multiple arenas, court filings, press briefings, and closed-door meetings with uneasy Republican senators. The Gale situation cut deeper because it was personal. This wasn't an agency defying an order through bureaucratic inertia. It was the president himself posting from his account in the small hours, targeting a specific judge by name. Compliance rested solely on Trump's restraint. No staffer could retract those words. No surrogate could soften the blow. Every subsequent post became part of the official contempt record, building a paper trail of defiance that lawyers watched with mounting alarm. The doubling of the fine from an earlier $5,000 contempt sanction signaled escalation. Judges don't impose such patterns lightly. It was a calculated message. Each violation would cost more, the documentation would grow thicker, and the path to serious sanctions would shorten. Gales had laid it out plainly, citing the need to protect the judiciary's independence. This was no bluff. It was a judge placing his reasoning on the eternal record, language destined for law review articles and constitutional debates. Compounding the stakes was a rare public intervention from the highest levels of the judiciary. In March 2025, Chief Justice John Roberts, known for his restraint and institutional caution, had issued an unusual statement. Roberts rarely waded into political fray. He avoided interviews, eschewed social media, and ran the Supreme Court with deliberate silence on controversies. But the pattern of attacks on federal judges had evidently crossed a threshold. Impeachment, he declared, was not an appropriate response to disagreement with judicial decisions. It undermined the separation of powers, eroded public confidence in the courts, and threatened the constitutional order. The message was clear, backed by the full institutional gravity of the Supreme Court. Now, just over a year later, Trump had publicly crossed that line. His all-caps demand for Gale's impeachment didn't exist in a vacuum. It defied the Chief Justice's explicit framework. Gales referenced that very principle in his order, elevating the document from a single-judge rebuke to an enforcement of the judiciary's highest articulated norms. This alignment carried immense weight. It wasn't one Obama-appointed judge versus the president. It was the federal judiciary speaking through layered authority, pushing back against perceived threats to its core function. Senators on Capitol Hill whispered about potential hearings while members of Congress debated the implications for oversight. The White House found itself navigating a minefield where every statement risked further contempt findings. The Epstein dimension added layers of political toxicity. In a midterm election year, persuadable voters in swing districts saw a troubling tableau: a president fined for attacking a judge, invoking impeachment over a dismissed case tied to Epstein files, all while the Chief Justice had drawn a red line against such tactics. images of the birthday card, references to the files, Trump's fiery responses. They painted a picture not of unyielding strength but of a leader ensnared in personal battles that distracted from governance. Republican candidates found themselves fielding questions at town halls not about economic wins or border security, but about contempt fines and judicial wars. The strategy meant to bury the Epstein story had instead supercharged it, turning a lawsuit into a self-perpetuating engine of coverage. This wasn't mere partisan drama. It raised fundamental questions about American governance. In a democracy, public officials, including judges with lifetime appointments, face accountability. Criticism is vital. Debate strengthens institutions. But when does legitimate speech cross into dangerous intimidation? Gales hadn't ruled arbitrarily. His 17-page opinion laid out the actual malice standard, the evidence gaps, and the precedents with exhaustive care. Any appellate court could review it transparently. Responding with presidential calls for impeachment wasn't robust debate. It was leveraging the bully pulpit to pressure the legislative branch into removing a judge for faithful duty. Both Gales and Roberts had named it precisely, an assault on judicial independence that, left unchecked, could unravel the checks and balances designed to prevent tyranny. The parallels to the deportation contempt fight illuminated the trajectory. In the Boasberg case, institutional defiance led to a full constitutional clash. Resources drained, alliances strained, optics suffered, but that involved layers of command. Here the contempt was personal, tethered to one man's keyboard. Escalation risked Supreme Court intervention, a showdown that could paralyze Washington at a critical juncture. Trump faced an amended complaint deadline in the Wall Street Journal case by April 27. His team had to weigh continuing the fight or conceding ground. Meanwhile, every Truth Social post tested the contempt boundaries. Continued attacks meant rising fines, a thickening evidentiary record, and the specter of harsher sanctions. Backing down might stabilize the immediate crisis but left the Epstein narrative and judicial losses festering. As the days unfolded after April 14, the tension thickened. Trump posted again, calling the fine a disgrace and the system rigged. Each word documented defiance, lawyers scrambling to advise caution. Public reaction split along familiar lines. Supporters saw a fighter battling a deep state judiciary. Critics viewed a leader eroding norms for personal vindication. Legal scholars debated on airwaves and in op-eds, drawing historical parallels to past presidential judicial clashes. Andrew Jackson's defiance, FDR's court packing scheme, but noting this felt uniquely modern, amplified by social media's instant reach. The emotional stakes ran deep. For those who revered the rule of law, Gale's order was a beacon of courage, a judge refusing to be cowed. For Trump loyalists, it symbolized elite resistance to a disruptive outsider. The nation watched, divided yet riveted, as the story intertwined with other fronts, immigration blocks, January 6 civil suits, tariff battles. This wasn't just about one $10 billion lawsuit or one $10,000 fine. It was about a presidency defined by open warfare with the judiciary, testing whether democratic institutions could withstand the pressure. In the quiet moments between posts and rulings, one sensed the weight of history. The founders envisioned friction between branches as a feature, not a bug, ambition countering ambition. But they never anticipated a social media presidency or files from a deceased financier's estate reshaping political reality. Judge Gales had drawn his line with precision and principle. The president faced a choice: heed the warning or push further into uncharted territory. Whatever came next, escalating sanctions, congressional involvement, or a fragile de-escalation, would echo far beyond one courtroom. It would test the resilience of the republic, the independence of its judges, and the limits of executive power in an era of relentless visibility. The fine stood as a symbol, small in dollars but monumental in precedent. Democracy's poison, Gales had called the threats, and the order aimed to administer an antidote. As April stretched toward its amended complaint deadline, the nation held its breath. Would restraint prevail, or would the confrontation spiral, consuming the political landscape? In the high-stakes theater of American power, this chapter was far from over. The players, president, judge, chief justice, senators, and citizens, moved across a stage where every word, every filing, every post carried the potential to reshape the constitutional order for generations. Expanding outward, the broader context revealed deeper currents. Trump's second term had opened with bold promises on borders, economy, and undoing prior policies. yet legal entanglements repeatedly diverted focus. The National Guard deployments in cities like Portland had sparked their own lawsuits, with Oregon and Portland challenging federal overreach under statutes like Section 12406 of the U.S. Code. Judges scrutinized claims of rebellion, finding protests largely peaceful despite sporadic violence. These rulings intersected with the contempt fights, painting a portrait of an administration aggressive in asserting executive will but repeatedly checked by courts. Emotionally, the saga tugged at America's self-image. Citizens in coffee shops and living rooms debated whether this was accountability or vendetta. Families with military service recalled oaths to the Constitution, not individuals. Young lawyers saw Gale's order as inspiration, a model of reasoned defiance. Older voters remembered Watergate-era reckonings, wondering if parallels held. The drama unfolded with suspenseful rhythm. Ruling drops, posts fly, fines mount, implications ripple. No one could predict the endpoint, but all felt the urgency. As the paper trail grew, Gale's strategy emerged clearly: not public embarrassment, but meticulous documentation. Each warning, each doubled penalty, built toward potential escalation. Trump's team, reportedly horrified, navigated a minefield where silence risked weakness and speech invited sanctions. The Epstein shadow lengthened every discussion, questions persisting despite dismissals. What truths lay in those files? How would history judge this intersection of personal history and presidential power? Ultimately, this confrontation transcended personalities. It probed the enduring question: can a republic survive when its branches turn adversarial not in policy but in existential challenge? Gale's words, poisoning democracy, resonated because they evoked fears of erosion, of norms fraying under pressure. The $10,000 fine was entry point to a larger reckoning. Senators might investigate, the Supreme Court could intervene, Congress could weigh impeachment powers ironically turned inward. Through it all, the narrative pulsed with human intensity, a judge's resolve, a president's defiance, a nation's anxious vigil. In the end, the story of April 14th wasn't merely legal or political. It was profoundly human, a moment where institutions spoke through individuals, where power met principle, and where the future of democratic balance hung on choices yet to unfold. The Republic had weathered storms before. Whether this one strengthened or strained, it would depend on the restraint, wisdom, and courage displayed in the days and months ahead. The opening act had closed with a fine and a warning. The full drama promised revelation still to come, each twist pulling the viewer deeper into the high-stakes unfolding of history. Historical echoes provided little comfort. Past presidents had clashed with courts. Jefferson with the Marshall Court, Lincoln suspending habeas corpus, FDR's court-packing threat, but none had wielded the instant megaphone of social media. Trump's personal, real-time attacks created a new paradigm. Every post carried presidential authority yet invited personal accountability. The contempt case against him as an individual, rather than against an administration, carved out uncharted territory. If Gale's moved toward harsher sanctions, the Supreme Court would almost certainly be forced to intervene. That prospect alone could dominate the national agenda for months, crowding out priorities like immigration reform, tariff negotiations, and economic policy. The emotional intensity of the saga reached its peak in the small hours when new Truth Social notifications lit up phones nationwide. Each one carried the potential to shift markets, influence lawmakers, or deepen the contempt record. Trump's supporters rallied with familiar defiance. Legal analysts dissected language for signs of strategic retreat or further provocation. Foreign governments watched with a mixture of concern and opportunism, wondering whether American instability might create openings abroad. Allies in Europe and Asia quietly consulted their own intelligence briefings, assessing risks to global stability if the world's leading democracy descended into prolonged institutional warfare. Through it all, Judge Gales remained steadfast. His order had been clear: threats of impeachment for legitimate judicial rulings poisoned democracy. The $10,000 fine was both punishment and warning. Further defiance would invite stronger medicine. Legal scholars predicted that if the pattern continued, Gales could impose daily fines, refer the matter to disciplinary bodies, or even recommend congressional action, though the latter would ignite its own firestorm. The judiciary was asserting its independence not with grand speeches but through meticulous paperwork, precedent, and principle. As spring deepened in Washington, cherry blossoms gave way to warmer days, yet the political temperature only rose. The deportation contempt precedent with Judge Boasberg offered a cautionary map. That earlier confrontation had drained resources, fractured alliances, and forced uncomfortable public defenses. This one felt more intimate, more personal, and therefore more volatile. A sitting president facing personal contempt sanctions occupied ground no previous administration had trod. The constitutional questions were profound. Where exactly does executive immunity end when speech itself becomes the violation? How does the judiciary enforce its dignity without appearing partisan? Can a republic function when one branch openly questions the legitimacy of another? These were not abstract debates. They touched the daily lives of millions. Parents explained to children why judges mattered. Veterans reaffirmed their oaths. Business owners weighed economic uncertainty against political loyalty. The story had transcended cable news and become part of the national mood, a lingering anxiety that something fundamental was being tested. Trump faced an impossible bind of his own making. Continuing the fight kept the Epstein narrative alive and invited escalating penalties. Standing down risked projecting weakness at a time when strength was his brand. His instincts honed over decades favored combat. Yet the institutional forces arrayed against him, layered judicial opinions, the Chief Justice's public stance, mounting legal bills, political collateral damage grew heavier by the day. April 27th would bring its own reckoning. But the larger battle stretched far beyond any single deadline. In quiet corners of the Capitol, elder statesmen from both parties recalled simpler eras of institutional respect. They spoke of unwritten norms that once guided behavior even amid fierce disagreement. Those norms now seemed relics of a gentler time. The modern arena rewarded spectacle, virality, and unrelenting pressure. Whether the Republic's ancient guardrails could hold under such force remained the central question of the age.